Well, welcome to the North Texas Church of Freethought's weekly Sunday service. We hold these by Zoom internet conferencing, except for generally the first Sunday of the month when we get together in person at a local hotel. If you would like to join us for either or both, please go to our website and enter your email address at the bottom of any page so you get the weekly notice of what we're planning that week. Post our presentations on YouTube, and there are quite a few of them there now, and we also have our own website with a lot of material there also. Please visit us on Facebook and Twitter. There's our website address there. We're also giving some consideration to posting material on TikTok, although some bad guy, some villain has appropriated our ID there. If you look up Church of Freethought on TikTok, it's not us. It's some creepy person with weird stuff.
Oh,
So before we get going on what I've been working on, I want to just show you a little bit of Marrakesh in Morocco.
oh, that's
One of us,
beautiful.
one of us is there right now, and that's Greg. Remember, he's going to be spending, I think, 4 months in Africa. So I just received an email from him, so I scrambled this morning to add these 3 pictures that he sent me. So there's a very pretty little scene from Marrakesh, and here's another little narrow street, and that's Greg's post to me on the side there, Marrakesh, Morocco. He feels that he's quite safe there. He's in Old Town. He loves the food and loves the Moorish architecture. And he's talking about how, of course, the French were in that area and they speak French, but also Arabic. And when he was looking to buy honey, they told him Spanish. But when the Moors came through there and went up to Spain, I guess they dragged back Spanish. Not sure what the reason for that is. And then here's one more shot that he included. So not long ago, we had a brief presentation on the First Amendment focusing on the Establishment and Religious Liberty Clauses, and this is a favorite subject of unbelievers such as ourselves, and should be to all Americans. Oh, there's a previous slide. There we go. Something got dropped out. Oh, well. This is a quote from William James, the American 19th and 20th century psychologist and philosopher who famously described one's total reaction upon life as being religion. That's what he said religion is. And as we talked about when we reviewed the First Amendment, what religion is something that we really don't want the government defining, because there would be all opportunity for mischief with that. Most people seem to think that religion is generally synonymous with superstition and supernaturalism. Most atheists associate religion specifically with a sort of godism or theism that features in the Abrahamic religions of Judaism, Christianity, and Islam. But there's no agreed upon definition among scholars, so this, I think, is as good a definition as any, and it certainly makes enough room for people like ourselves to be able to say that we do have a religion, so to speak, in the sense that we have religious opinions, and our opinions count too. So the First Amendment, as we know, is the first of the first 10 amendments to the U.S. Constitution, collectively known as the Bill of Rights. These were formally ratified just December 15th, this past Thursday, in the year 1791. So that's what we're going to consider a bit more this morning. It is a huge subject, so we'll need to do it in general terms and taking into account some interesting side issues. So we do history quite a bit in our church, but that's because history has quite a lot to do with religion. It always has. Think about it. History, our past, how it unfolded and why, its many twists and turns, and even how it came to be interpreted, are important elements of culture and how we think and feel about everything. Much of Holy Scripture purports to be history. In fact, myths of all kinds, fiction generally, amount to historical fiction. This is because fiction needs context, and that context can be nothing other than familiar situations from the past, or present circumstances, or what we may imagine the future may be like. Without that kind of context, the stories we tell would not have meaning for us. Even the sciences exist in a historical context, for they, like religion, are a product of the search for understanding that necessarily took place in history. Both have been subject to many of the same influences that historians consider, There's an important distinction, though, as Ricky Gervais, the British comedian, likes to point out. If we take something like any fiction, any holy book, I wish I could do it in his accent, and destroyed it, in 1,000 years' time, that wouldn't come back just as it was. Whereas, if we took every science book and destroyed them all, in 1,000 years, they'd all be back the same. Of course, the fiction that would come back that he's talking about, even though it would surely have similar ideas and themes, would be strange and unfamiliar. In a reconstituted world where all knowledge had been destroyed and everything had to be made up all over again, the one true God before which every knee must bend might be Xantar or Biff. The fairy tales that now have to be believed in to escape damnation would not be the same. Everything that is considered to be so critically important in religion would be different. But the science would be easily recognizable. Even if the Pythagorean theorem was known as Wilbur's rule, the square of the hypotenuse of a right triangle would still be equal to the sum of the squares of the other two sides. Now, besides being the products of contingent history, the Constitution and Bill of Rights are political subjects. They always have been. Meanwhile, we here at the North Texas Church of Freethought have always been at pains to say that we don't tell you how to vote. We take no position on most public policy issues aside from noting, with disappointment and often with alarm, that facts and reason so frequently take a back seat when it comes to how issues are discussed. That said, one's total reaction upon life obviously has a lot to do with the sort of laws and political institutions that you may prefer. But that doesn't mean that one cannot distinguish between the objective facts and reasons and the subjectivity that go into those preferences. And that's the spirit in which we'll look at our subject today, the Bill of Rights, and whether it was a blunder or not. Caveat, I'm not a lawyer, let alone a constitutional lawyer or a legal expert. On the other hand, the Constitution begins, we the people, not we the lawyers. Somebody once assured us that the struggle to preserve and defend the United States at a time when its survival was very much in doubt is a matter of ensuring that government of the people, by the people, for the people, shall not perish from the earth. Well, the Constitution as we have it was famously drafted by a convention that met beginning on May 25th, 1787. A total of 55 delegates from 12 states attended. Rhode Island, distrustful of the idea of a stronger central authority, refused to send any delegates. The meeting was supposed to consider and make recommendations for amending the Articles of Confederation, the first plan of association that the former colonies, now new states, relied on. The delegates decided instead, and just how this happened is another story for another day, to draft a plan for a whole new government. The U.S. Constitution was completed and submitted to the states on September 17, 1787. Many today would be surprised to learn that at the time it was not immediately accepted and recognized as a work of sublime elegance and wisdom. It was certainly not regarded as sacred scripture worthy of any reverence, much less honor. Oh no. Rather, it was assailed by many as a monstrous plot to reimpose tyranny on Americans. For one thing, it had no guarantees of people's liberties, no Bill of Rights. Critics also complained that it gave the central government too much power, especially the president, who they feared presaged the reimposition of a monarchy. And they feared that Congress would not and could not represent the people, being too distant and likely to become an oligarchy. These objections were often expressed, believe me, having read some of it, with a great deal of rancor and outrage. It wasn't all niceness and courtesy. Those who supported the Constitution called themselves Federalists, and they labeled their opponents, effectively it might be added, Anti-Federalists. This in itself is interesting, since the Anti-Federalists, they were really the ones who supported the idea of a federation of states. Federalists were really nationalists, seeking to establish a strong central government to which the states would be subordinate. But then, as now, those who effectively label their opponents, those who control the narrative, quote unquote, they are the ones who enjoy a significant advantage. Another big advantage of the Federalists was that they enjoyed great popularity in the urban areas. Although in those days the cities did not have so much of a concentration of population as now, they did have the newspapers and a preponderance of the moneyed interests. They also had a greater motivation to have a strong central government because a stronger central government would have more economic and military power. The rural areas and plantations, especially in the South, did not share these interests as much, and being distributed over a wider area, they were more skeptical that a central, faraway government would have much to offer them, especially given that in those days, when everything traveled more slowly, they were less connected. So they preferred a similarly decentralized style of governance. And that, in turn, was why people like Thomas Jefferson advocated for agrarianism, preferring that Americans busy themselves with agriculture and meeting most of their own needs. He would have made a great survivalist or off-the-grid type of person today. As he put it in his 1787 Notes on the State of Virginia, and I know it's a long quote, "Those who labor in the earth are the peculiar deposit for substantial and genuine virtue. Corruption of morals in the mass of cultivators is a phenomenon of which no age nor nation has furnished an example. The proportion which the aggregate of the other classes of citizens bears in any state to that of its husbandmen is the proportion of its unsound to its healthy parts. The general operations of manufacture let our workshops remain in Europe. Mobs of great cities add just so much to the support of pure government as sores do to the strength of the human body." About that. Jefferson, of course, did not and perhaps could not have foreseen the mechanization of agriculture that would follow in the years afterwards, to the point where instead of 90% of workers being needed on the farm in 1790, only 2.6% were needed by the year 2000. Yet even now, the USA remains a net exporter of agricultural products. Fun fact, take a guess, what's our biggest agricultural export? The answer, soybeans. The exports of soybeans are more than twice as much, worth twice as much in dollars as any other single product. That's our claim to fame. We export soybeans. As for the great mobs of great cities that Jefferson likened to sores on the human body, a huge majority of Americans now live in cities. Maybe that, and not the lack of Bible reading in schools, maybe that accounts for what some claim is the decline of morals in our country. We live in cities. Yet Jefferson, so far as I've been able to learn, he did not oppose the ratification of the Constitution. He was mainly considered an anti-Federalist because he opposed the Federalist Party, which came later. But Jefferson was among those that thought it needed a Bill of Rights, that was needed. Many others objected on this basis as well, and this was probably the main objection to the Constitution. But it was also said that the Constitution gave the president too much power because it did not limit the number of terms that could be served, set up the conditions for monarchy. Federal courts and Congress were also given too much power, the opponents said, and they feared that Congress would become an oligarchy. Opponents had a further objection to the Constitution, which was that the states and their territories were simply too large for a central power to govern effectively. And it was true that at that point the United States was already more than 4 times the size of Britain and more than twice the size of France. The United States is today the 3rd largest country in the world after Russia and Canada, with 6.1% of the world's dry land. Of course, the advance of technologies of communication and transportation have been driving globalization, so governing such a large area is not so difficult now as it was in the 18th century, but the world was a long ways away from that at that time. During this time, Alexander Hamilton, James Madison, and John Jay, there you see them, John Jay on the left, Madison in the middle, and Alexander Hamilton on the right, they wrote a series of 85 essays, later collected and known as the Federalist Papers, explaining and defending the Constitution. They wrote under the pseudonym Publius, because Madison and Hamilton had both been delegates to the convention and they did not want to betray any confidences. They addressed a wide variety of important issues relating to the aims of the Constitution, both general and specific. They also addressed the objections of the Anti-Federalists and tried to dispel the idea that the absence of a Bill of Rights was a nefarious plot to impose a tyranny. The important context here is that the formerly British colonists, now American citizens, knew of and attached great importance to Magna Carta. There you see King John seated. Magna Carta was an agreement that the English nobility in 1215 forced upon then King John, who's being made to sign the thing. And what it did is it protected the nobles from certain abuses. At that time, of course, the monarch held absolute political power, and everyone then believed that this power was held by divine right. So, to assert that there could be abuses and that something had to be done to prevent such abuses, that monarchs could not just do whatever they pleased, that was a substantial affront to the accepted principle. Magna Carta, by the way, was annulled the following year by the Pope. Then it was watered down a bit and revived after King John's death by the regents of John's heir the following year. Principles were incorporated in other treaties and reissued in other forms after that, passing into England's statute law by 1297. By the early 17th century, English jurists and historians cited Magna Carta as standing against the divine right of kings and for the concept of individual liberties generally, even though in the beginning it only protected those wealthy people, the barons. So it was a very powerful argument to say that the Constitution was flawed by its not having any kind of assurances against the abuses of government power. The new nation believed many needed something like the guarantees of Magna Carta. For this very reason, many of the 13 colonies, now new states, they already had their own bills of rights and things like the Virginia Statute of Religious Freedom of 1786, even though they were not ruled by any kings. Alexander Hamilton was frustrated by this criticism. Demands that the Constitution be supplemented with a Bill of Rights, that didn't make any sense to him, and understandably so, for the Constitution was really an entirely new idea in terms of where the civil power originates. It certainly didn't come from God. This idea was new enough that, like many new ideas, it was met with a certain uncomprehending puzzlement. People apparently just did not get it. Remember that at that time, for most people, even many, if not most educated and intelligent people, the Bible was the standard of truth in all things, including politics, and it had been this way for many centuries. Paul, the originator of Christian theology, if not the originator of Christianity altogether, in the letter to the Romans 13:1, proclaimed, "Let every soul be subject unto the higher powers, for there is no power but of God. The powers that be are ordained of God." So here's the very word of God, the Bible, according to Christianity, stating the divine right of kings and without any qualifications. Whoever held political power had the divine right to exercise it absolutely, and everyone else was duty bound to accept their authority. I guess we talk about usurpations and all the assassinations and so on that took place over the years, but I guess those were ordained by God too. But the new United States had already been asserted to be founded on a very different political theory. Thomas Jefferson didn't invent it, to be sure, but he stated it quite clearly and famously in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal and endowed with certain inalienable rights, and among these life, liberty, the pursuit of happiness, and that the purpose of government is to secure those rights. And governments get their just powers from the consent of the governed. That was a radical idea, radically different than what Paul asserted in Romans and what the faithful throughout Christendom had always understood as unquestionable fact. Here is an entirely new and different political theory, that the power of the government, whether exercised by a monarch or others, by whatever means, is not top down, but bottom up. That is, it does not come from a higher or divine authority, rather, it is power that has been delegated to it by and is conditioned on the consent of the governed. Clearly, in this respect, the new United States was a stunning departure from a strictly Christian nation founded on biblical truths. It was certainly a departure from the political principles that governed all other countries dominated by people practicing Christianity. 56 signers of the Declaration from all 13 colonies, they knew that, and so did all the colonists who read it, none of whom, so far as I've been able to learn, ever called it out as being unbiblical or unchristian. So Alexander Hamilton's frustration with demands that the new federal constitution include a Bill of Rights was understandable. He addressed the issue in the Federalist number 84, the next to last of those 85 essays that I mentioned that were published between October of 1787 and August the following year. Here's what Hamilton wrote, and I'm going to go through a few slides here, and it's really worth considering closely. It has been several times truly remarked that bills of rights are in their origin stipulations between kings and their subjects, abridgments of prerogative in favor of privilege, reservations of rights not surrendered to the prince. Such was Magna Carta, obtained by the barons, sword in hand, from King John. It is evident, therefore, that according to their primitive signification, bills of rights have no application to constitutions professedly founded upon the power of the people and executed by their immediate representatives and servants. Here, in strictness, the people surrender nothing, and as they retain everything, they have no need of particular reservations. We, the people of the United States, to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Here is a better recognition of popular rights than volumes of those aphorisms which make the principal figure in several of our state bills of rights, and which would sound much better in a treatise of ethics than in a constitution of government. I go further and affirm that bills of rights in the sense and in the extent in which they are contended for are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers which are not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? I will not contend that such a provision would confer a regulating power, but it is evident that it would furnish to men disposed to usurp a plausible pretense for claiming that power. Oh, you can almost feel the exasperation in Hamilton's words. How he must have thought could his fellow Americans be such blockheads as not to understand that a government of limited, enumerated powers that are delegated to it by its citizens, none of whom have the power of right to tread on the liberties of others that they could possibly delegate to a government or anyone else, need not issue guarantees not to do what it has no authority to do. Worse, if it did give such guarantees, the implication is that it could otherwise perpetrate such abuses. This is dangerous inasmuch as it is not hard to find those who are eager to seize on such implications as a pretext to abuse. Well, what Hamilton said was to be feared has actually happened, as we know. Even the Supreme Court of the United States has now bought into the idea that Americans have no rights but those mentioned in the Constitution. That is why Roe v. Wade was struck down. And as we know from Justice Clarence Thomas' concurrence in that case, in his view, there's no right to same-sex marriage, no right to having sex in a way that the government might consider wrong, no right to contraception or to anything else not explicitly mentioned in the Constitution or that is not, quote-unquote, deeply rooted in the nation's history or, quote-unquote, necessary for ordered liberty. That could be an awful lot of things that Americans take for granted that they have a right to do, but that, in fact, they have no right to do. So was the Bill of Rights a blunder? Was it not a mistake that it was originally left out of the Constitution? Was Hamilton correct that a Bill of Rights would simply provide a colorable pretext and a plausible pretense for would-be tyrants to claim additional powers that they have no authority to exercise? As good as it was, Hamilton's reasoning was not good enough. It could not overcome past prejudices, and it did not convince opponents of the Constitution, including John Hancock and Samuel Adams of Massachusetts. So an agreement was negotiated, the Massachusetts Compromise. In return for the Anti-Federalists supporting the ratification of the Constitution, the Federalists would support the passage of a Bill of Rights, and so the Constitution was ratified by Massachusetts and 5 additional states, 4 of which, like Massachusetts, attached a demand for a Bill of Rights. This brought the requisite number of states' approval on June 21, 1788. After elections later that year and early the next, the Constitution went into force on March 4, 1789. Well, James Madison and others got to work on crafting a Bill of Rights soon after that, and of course, they were obviously aware of the debate that had taken place over the issue and of Hamilton's warning that a Bill of Rights would be dangerous. Their solution was the 9th and 10th Amendments, and here they are. Enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, and that the powers not delegated to the United States by the Constitution. Certainly a pretty blatant ruling there that there are powers that were not delegated nor prohibited by it to the states are reserved to the states or to the people. Now, most Americans are not familiar with these 2 amendments, but they're a full fifth, 2 of the 10 amendments of the Bill of Rights. But in light of Hamilton's warning about a Bill of Rights, they should perhaps be considered as important as any of the others. These two are certainly as important as the First Amendment's guarantees. So, why do we hear so little of them? How many of us as school children were taught anything about them, of what they mean and how and why they got there? Well, you're finding out now. When the 1965 Griswold decision was handed down invalidating a Connecticut law that had stood for 86 years, criminalizing the use of contraception, or it even criminalized assisting, abetting, counseling, causing, hiring, or commanding someone else's use of contraception. That opinion cited penumbras formed by emanations from specific guarantees in the Bill of Rights, including the Ninth Amendment. These penumbras and emanations protected a right of privacy, were also relied on in the 1973 Roe v. Wade decision. That linchpin, which was continually and relentlessly ridiculed by anti-abortion zealots, as well as strict constructionist and originalist judges that now control the U.S. Supreme Court, has now been pulled out, and there's no telling where this will ultimately lead. Justice Robert Bork. He was famously rejected for a seat on the Supreme Court of the United States in 1987 after being nominated by then-President Ronald Reagan. He was opposed by an array of civil rights and women's groups, including the ACLU, because of his views on privacy, voting, and other issues. During his failed nomination process, he stated that in his view, the court should not rely on the Ninth Amendment, as he regarded it as, quote unquote, an ink blot. Here's what Robert Bork said in response to questioning by Democrat Senator Dennis DeConcini of Arizona. If you had an amendment that says Congress shall make no, and then there is an ink blot and you cannot read the rest of it, and that is the only copy you have, I do not think the court can make up what might be under the ink blot if you cannot read it. Does this look like an ink blot to you? Or does saying it is an ink blot merely make clear what Hamilton had to say when he explained why the Constitution is itself a Bill of Rights, since powers not explicitly granted to the federal government may not be exercised by it? There's another wrinkle, I'm afraid. There's another, much larger ink blot in the U.S. Constitution. And you probably didn't hear about this in school either. It's one that the founders and their generation were well aware of. Well, when they all read it when the Constitution was proposed to the states. And this must have motivated their demands for a Bill of Rights and their being unpersuaded by Hamilton's insistence that no such Bill of Rights was needed. Talking about Article 1, Section 8, because there the Constitution lays out the power of Congress to tax, borrow money, regulate commerce, establish rules for naturalization and bankruptcy, coin money, punish counterfeiters, establish post offices, raise an army and maintain a navy, and so on and so on. But the last of these enumerated powers, here's the enumerated power, is this: make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Now, the Commerce Clause in paragraph 3, Article 1, Section 8 is often singled out as being abused too, for example, and this actually happened. It allowed the federal authorities to stop people from growing vegetables in their own garden for their own consumption on the grounds that it interfered with interstate commerce. But it had to work together with this necessary and proper clause, often called the elastic clause. That's what allows the Commerce Clause and other things to be applied in such expansive ways. Goodness, think about it. If you're going to raise an army and maintain a navy and have a military, gosh, there's all sorts of things you need to do. You might have to force everybody to take vitamins every day so that they'll be healthy when they are drafted into the military and so on. Well, the founders in their generation were well aware of this necessary and proper clause. It was one that was singled out for attack by opponents of the Constitution as a glaring open door to tyranny. But it was defended by Madison and Hamilton. In the Federalist Papers 33 and 44, Madison actually wrote that without this clause, quote, the whole Constitution would be a dead letter. How can that be? Why couldn't the Constitution simply assign specifically enumerated and described powers to the government? Or, in the alternative, if such vague and elastic powers are acceptable, what's the point of enumerating and describing the others? The Constitution could have been made a lot less lengthy than it is. It's already one of the world's briefest, if not the briefest document establishing a plan of government. But it could have just said that Congress had power to make all laws which shall be necessary and proper to, as the preamble puts it, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Short and sweet. Why bother to mention an Army and Navy when an Air Force and even a Space Force can be later justified by that ink blot of the necessary and proper clause? Well, there's the hint right there. The elastic clause was needed because the Constitution needs to be elastic. It needs to be flexible because it needs to be able to adapt to changing circumstances. It needs to be a living Constitution. There's a term that the far so-called right conservative hate, but it needs to be a living Constitution in the same sense that living organisms must be able to respond effectively to the opportunities, challenges, and threats that they encounter. A government of, by, and for the people, like the people themselves, must be free to respond to the circumstances of the moment. That is a huge challenge, obviously, but it is one that every single one of us must face. There it is, the living Constitution, demonized by people like Judge Robert Bork and most of the members of the current Supreme Court. And the reason it needs to be living is, as Søren Kierkegaard, the 19th century Danish philosopher, he's often considered the founder of existentialist philosophy, he said, life must be lived forwards, but it can only be understood backwards. Or to put it another way, we struggle in the present as we plan for the future, but we won't be able to understand any of it until it becomes the past. This is as true for nations and the world as it is for us as individuals. And of course, this brings us back to that theme, that subject of history. So, was the Bill of Rights a blunder? Hamilton saw it that way, and more than 200 years later, we've seen that it has been used against us just as he predicted. On the other hand, the Bill of Rights may well have limited the elastic clause, at least to some degree. We haven't even touched on the subject of the 14th Amendment, and we're going to have to do that in the future, too. The Bill of Rights was a blunder. The mistake was that the 9th and 10th Amendments were not a sufficient elastic clause for freedom and human rights, as Article 1, Section 8, Paragraph 18. 9th and 10th Amendments needed to be more elastic, or they need to be seen as more elastic. Why should the rights of human beings be less elastic than the power of government, after all? Or perhaps this problem tells us something about ourselves, about humanity, that the willingness to dominate others and demand conformity and obedience from others is so much stronger than the willingness to live and let live, to enjoy our own liberties, pursue our own happiness, and allow others to do the same. What is clear is that Hamilton promised a government that could do nothing but what we the people permitted it to do. We are instead lurching toward a world in which Americans can do nothing but what the government permits them to do. But it remains up to us nonetheless. As Judge Learned Hand said in his famous Spirit of Liberty speech, and I inserted this as well just to remind us, talking about the willingness of people to dominate and demand conformity and obedience from others. Jefferson well knew this, and that's really a principle that the Founding Fathers bequeathed to us that is not much mentioned. But as I said, in the 20th century, 1944, Judge Learned Hand put it this way. I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. But whatever we can do to nurture this spirit of liberty is a good thing. We dare not take it for granted, and it is foolish to trust that others will do the work for us. And I think lots of people do both. They take it for granted and they trust other people are going to take care of it. As in our personal lives and every day of our lives, we must care. We must keep the spirit of liberty alive. We must put facts and reason into its service, and we must think, live, and act accordingly. So thank you and good morning. Hope that's given you something to think about. maybe for the rest of this week at least, and maybe for longer. Reminder of our principles: our church, reason, enjoyment, appreciation, and love. I've already gone on for a while here, so I won't go into detail, but these things spell real. How interesting. And a reminder, too, that Freethought is not free. The financial and other contributions of our members are so much appreciated. You know who you are, I know who you are, and thank you so much. It is so important. Your church depends on your continued support. So you can support your values. These are your values by supporting the North Texas Church of Freethought, because we really can do together what none of us can do on our own. None of us can do on our own what we can do collectively. Same as the government and the Bill of Rights and all the rest of it. So join us in promoting facts and reason, celebrating doubt. Nothing for facts and reason to work on if we don't doubt. Demonstrate your commitment by being the future you wish to see. That's a challenge, but we need to think about that. Probably think about it more than we do, but there it is. Finally, Melius Facet, which means do better. With that, we'll move on to question and answer. Be glad to expound. My head is still filled with all sorts of things related to what I just discussed here. So I may, if you're wondering about anything, feel free to ask, or we can talk about other things like what you want from Santa for Christmas. Thanks again.